and welcome to the set of the Future of Europe here at the Catholic University of Lille. I'm Syrine and today I'm welcoming Inès.
Hi.
And Salma.
Hello, it's a pleasure to be here.
Students in the Catholic University of Lille in the Masters of International European Law here. Nice to meet you. So today our topic relates extradition and citizenship within the European Union. Could you tell us more?
Well, there is something called the European Arrest Warrant, which is a simplified cross-border judicial surrender procedure that was put in place in order to replace previous extensive extradition procedures that were existing before between member states. Look, what if I tell you that tomorrow you were the subject of an European arrest warrant? So you did something illegal and that you were pursued by one of the member states. And they were concerned about the protection of your fundamental rights within these member states, which those fundamental rights are defined by EU law and that are here to ensure that you are being treated fairly. If you feel that your rights are not being protected, or for example, that the authorities issuing that warrant have overstepped their bounds, you would not think that the system was treating you fairly, would you?
No, I would think that my rights have been breached.
You really catch my attention. But what are the legal bases? Can you explain more about the functioning of extradition between member states?
Yes, of course. So I just mentioned the European arrest warrant. So since January 2004, convicted or suspected individuals can be transferred to another member state in order to enforce convictions or criminal prosecutions. It has removed all the difficulties, by that complexity and delays that existed before with regard to extradition procedures.
Yes, exactly. Extradition requests nowadays form an important concern regarding international relations, especially when they involve the European Union and a third state. Extradition matters have been settled. Extradition cooperation between member states implies the principle of mutual recognition and therefore the obligation to set aside national sovereignty. For instance, various states' constitutions impose the extradition exemption on their own nationals.
Of course, we can imagine how delicate this question must be. What about the cooperation between the member states in this important topic? Does it create conflicts?
You're right. This topic creates a lot of conflict within the European Union. So that's why the Court of Justice of the European Union has to take position on those questions. The ability for the member states to cooperate on extradition matters have been settled by the European Convention on Extradition, signed in 1957. So the Article 1 of this convention provides the obligation for the contracting parties to surrender to each other, and I quote, all persons against whom the competent authorities of the requesting member states are issuing proceeding for an offense or for a detention order. So it is a binding international agreement. All parties have to stick to it under their national laws. But as Inès mentioned earlier, there is issues regarding the rights of individuals. You, Inès, and me are citizens of the European Union, and therefore this quality confers us rights that can lead to issues when it comes to extradition.
And how these rights are protected regarding extradition? Because the example you gave us sooner was really relevant.
Thank you. So the principles of mutual trust and mutual recognition are considered as the cornerstone of judicial cooperation in criminal matters within the functioning of the European Union. That's a position that was recalled by the Court of Justice, notably in the case, in the Jao case from 2019. However, the Court of Justice has difficulties when trying to balance those principles with the need to protect the fundamental rights standards. Furthermore, Article 1, Paragraph 3 of the framework decision that I mentioned earlier exposes the obligation while executing the European arrest warrant to respect fundamental rights principles that are protected by Article 6 of the Treaty of the European Union, which are important to respect in order to allow the application of EU law to be uniform.
Has the Court of Justice of the EU positioned itself on the question?
Yeah, so we have the example of the case Puig-Gordy and others. Here there was a concern with regard to a potential risk of that the individual against who an European arrest warrant was issued against by a certain court, that there was a risk with regard to that court, that the court was maybe lacking jurisdiction, and therefore that would lead to an infringement to the fundamental rights of a fair trial, for example. So this court recalled that in the case that the refusal to execute the warrant has to be strictly interpreted. In case, and I quote, the person runs a real risk of infringement of his or her fundamental rights to a fair trial, which is up to the court to interpret, and by following the grounds on framework decision that I mentioned, but with regards to Article 3, 4, 4A, and 5 of that decision, and which maintain mutual trust and the effectiveness of EU functioning.
Thank you, Inès, for your analysis. But has the Court of Justice of the European Union ever authorized and justified extradition to a third country? Does extradition prevails over rights such as the freedom of movement, for example?
Yes, the Court of Justice of the EU authorized the extradition of an EU citizen to a third country in the case SM versus, I will not try to say it in German, but versus the Higher Regional Court of Munich. So the court justified the extradition authorization to prevent the risk of impunity, and this is really important. Indeed, on 2020, Bosnia and Herzegovina requested that the Federal Republic of Germany extradite a Bosnian national who had been living in Germany since 2017 and who also holds the European citizenship through his Croatian nationality, in order to enforce a 6-month custodial sentence for corruption.
But why did the court authorize it, since the individual lived in German territory since 3 years? Isn't he protected, as Inès previously said, regarding the protection of its fundamental rights?
It's a really interesting question, because this is exactly the issues that were raised in the case. Germany, because of its commitments under the European Convention on Extradition made to Bosnia and Herzegovina, was in principle obliged to extradite the requested person. But the Higher Regional Court of Munich asserted that EU law precluded extradition in this case, regarding the right of EU citizens' freedom of movement and to reside freely within the territory of the member states, but also regarding the prohibition on discrimination, all of that stated in Articles 18 and 21 TFU.
Then, regarding the protection conferred to EU citizens through these articles, can the requested person enforce its sentence in Germany? And this would then prevent extradition, no?
Indeed, according to German law, the requested person could serve the sentence in the requested member state, so here Germany, in order to avoid extradition. But Bosnia-Herzegovina must consent to this alternative solution.
And I'm sure they did not consent to regarding the European Convention on Extradition.
Well, you guessed right. They did not respond at all. So the Court of Justice ruled that in this case, the requested member states must actively search for the consent of the third states. in order for the sentence to be served in the territory of the member states. So this would ensure that the risk of impunity is prevented through an alternative solution that is less prejudicial for the EU citizens' rights of freedom to move within the territory of the European Union. Nevertheless, if that consent is not obtained, the court ruled that Articles 18 and 21 TFEU do not preclude extradition in this case. So it does not preclude Germany from extraditing the requested persons to an international convention, and here this is the European Convention on Extradition, because otherwise there would be a risk that the individual remain unpunished.
Have you any elements that we haven't heard yet and that you want to add relating to the subject? Inès, may I start with you, and then Salma, please feel free to continue.
So yeah, of course. So I would like to add, maybe on the case Puig-Gaudy and others, that the court finally positioned itself with regards to the possibility to issue a new European arrest warrant after an initial one was refused, since there are no provision provided from the framework decision. A new European arrest warrant can be issued. That's the answer of the court. And that may be because of new evidence, for example.
What about new evidence?
What I mean about new evidence is, for example, a new testimony, something that will transform the legal basis of the case and that will lead to reconsider the whole case. So this case sets a fundamental precedent for future cases that relates to the initiate new European arrest warrants against the same individual.
Yes, I would say that the launching of a new European arrest warrant against the same individual is a strong tool that the Court of Justice affirmed as a possibility, only issued thanks to new evidence, of course, to respect the fundamental principle non bis in idem, which is a legal doctrine that ensures that no legal action can be instituted twice for the same reasons. So I think that is a really good tool for the future of Europe, especially in matter of extradition and criminal proceedings, of course, to prevent the risk of impunity, as in the case that I've mentioned earlier. Indeed, the CJEU authorized the extradition of an citizen of the European Union to a third state to prevent and to avoid this risk of impunity, because if we do not extradite him, the individual would remain unpunished, and this is not possible. So it is, however, important to note that under the Charter of the Fundamental Rights of the European Union, extradition must be ruled out if there is any risk that the requested person could be subject to torture, to the death penalty, or to any degrading treatment in the third states. So once again, the court emphasized the importance of respecting fundamental rights and EU principle when it comes to extradition.
Well, thank you very much for your analysis and for telling us more about the future of Europe in matter of extradition. And that remains a really protected field thanks to EU law and principles. And to our viewers, thank you for your attention.
Thank you.
Thank you very much. Bye.